We will be waiting for few minutes for the participants to join. Ma'am, shall we start now?
Yeah, yeah, I'm ready. I'm just waiting for you guys whenever.
Yes, ma'am. Sure, ma'am. A very pleasant good evening to all of you. It is my great pleasure to welcome you all in today's webinar session with Ms. Abhisar Baragi ma'am on the theme Force Measure Clause and Dispute Resolution. Myself, Piyush Singh, the moderator for today's session, organized by YURIS JURA. YURIS JURA is an initiative of students of Amity Law School, Amity University, Chhattisgarh, started in the year 2020. YURIS JURA, yes, ma'am?
Go on, nothing. Please go on.
Yes, ma'am. YURIS JURA is an e-learning platform for legal learning aspirants which gives the opportunities to all the law aspirants across India. We have put an effort so that the law aspirants and the legal fraternity can associate with us. Moreover, it is an organization that always endeavors to offer an astonishing, cordial, and practical outlook with equal cooperation and participation from all. Basically, it molds the legal thought process which modernizes the socio-economic lifestyle. Before I invite our esteemed speaker for today's session, organized by YURIS JURA, I would like to introduce Ms. Abhisar Baragi ma'am. Ms. Abhisar Baragi ma'am is a member of Dispute Resolution Team in Delhi office of Khaitan and Company and specializes in civil litigation, arbitration, both domestic and international, and is also actively involved in giving advice, pre-litigation advisory to clients. She has completed her graduation in 2011. As a member of Khaitan and Company, she is representing a wide range of clients, that is, individuals and corporates, before various judicial forums, that is, Supreme Court, High Court, District Courts, National Green Tribunal, Consumer Forum, Appellate Tribunal for Electricity, Debt Recovery Tribunal, etc. Before moving further, I would like to focus on the chronology of this fruitful session. This session is divided into three segments.
Good evening, everyone. Thank you, Piyush. I am not really sure that if Piyush was able to complete what she was saying, or was there a connection issue, but I'll just continue. All right, those are impressive numbers for a Sunday evening. Thank you all for turning up. I hope I make it worth your while. Uh, at the outset, I understand that a lot of you in the audience are students, and this must be hundredth, thousandth webinar you are attending. So I'll try making it as less boring as possible. In fact, before I start, X amount of respect due to you. I think law as a subject is something which needs to be discussed and debated and argued, brainstormed in person. So all you guys have been reading it, learning it on a remote platform. That is very, very impressive. That said, I'd like to make this as interactive as possible. So you could ask questions. Whatever I can answer, I'll go ahead and answer. Whatever I can't, I'll relay it through the organizers. I hope that's okay with you all. Coming to today's topic, we're going to be talking about force majeure. It's a French term. I think we all have a license to mispronounce it, but I think that's the closest you get to it. Force majeure. Um, it's a French term which means superior strength, literally. And I guess somewhere uh, people dealing with law must have learned it the hard way, that they had to make some kind of a requisition for the unknown. And if you look at it that way, it is quite a unique concept that you're making a provision for the unforeseeable in the contracts. It's it is let's say it is very important at this point of time. In fact, it became very important at this point of time due to the pandemic. Now let me tell you something, and it's something that, between uh, amid the legal community, we'd all know that when you draft a contract, and you have one contract that you've drafted, which is your favorite contract, which you think is all comprehensive, all encompassing, and that becomes your base document for years to come. And I think that happens to almost everybody. So when you have a base document like that, whenever you go draft a new contract, you always go back to it and borrow at least the general terms of the contract, which nobody really needs to negotiate, or which nobody really is going to object to. Say, for example, you will be called party A and the other party will be called party B. No, that's not a term that you need to negotiate upon. That's a given thing. Or that the notices are going to be sent to your addresses, or your registered address is going to be this and this. So these are the terms that nobody really negotiates or fights about when a contract is getting negotiated. Force majeure till now used to be one of those clauses which you'd copy paste and put it up. And so what happened was that once the pandemic stuck, that is the first time we kind of understood the importance of the contract and what exactly we were supposed to do with it. Now, okay, I'm not able to see, but I hope that you guys have the PowerPoint presentation on your screen. Can somebody confirm if that is so? I'll just assume that you guys have a PowerPoint presentation on your screens. Any which way, so let's just say that with the pandemic, we kind of realized that there was a circumstance, there was a pandemic, which was something every single business was supposed to make provision for. Okay, I've been informed that it's not there on the screen, it's being shared. Let's just give it a moment. Yada, yada, yada. Yeah, we can just hop on to the third slide, I guess. The third one, which talks about fallout of industry shutdown. Yeah, this one. So this is what happened uh, with the pandemic. Obviously, the supply chain got affected. We couldn't contact the suppliers. We couldn't reach out to the buyers. There was obviously a slippage in payments, and all this led to all the contracts getting disrupted. Obviously, there were other contracts which were also affected, like employer-employee relationships, then banks and finances, business. But let's just come back to the first principle, the basics of it. So what happened was that, and I'll give you the example closest to you guys. E-commerce. You ordered things, you did not get the things in time, and you were told that there's a lockdown, there's a shutdown. We cannot access, we cannot step out, and thus we are not delivering. And there's going to be a change in schedule of delivery, or we are going to give back your money. So if you talk in layperson terms, there was a contract, and there's been a breach of contract. And now what happens? What are the consequences of this breach of contract. And this is where everybody dug out the force majeure. Now, if you just go to the next slide, please. When we talk about what happened in the pandemic and what was the consequence or what was the impact on contracts. So, basic terms, you entered into a contract, both sides had obligations. If those obligations are not fulfilled, there's a breach. If there's a breach, there are going to be consequences. Now, those consequences can be several. They can be one of the most common thing that gets attracted when you breach a contract is damages. So that is the monetary exposure bit of it. Then, if the contract provides for it, if you've not performed your contract, you might have to indemnify the other party or bring them par to wherever they were before the breach happened. So that is another thing. Specific performance, it's a statutory action. If you think that damages is not what you want the contract to be performed in terms of how it was supposed to be or how you had agreed upon, then you go for a specific performance. You go to the court, you file a case, and you say that this is how you want it to be done. Obviously, there are there are a lot of provisions that need to be followed, and then in those conditions is when specific relief can be gone for. Without getting into it, injunction, preventive action. Somebody goes to court and says that they've not performed the contract as per the contract. I'm holding their money, I'm holding their bank guarantee, or they have X amount of money of mine and they shouldn't be allowed to part with it, or they're supposed to uh, not allowed to get into a business with somebody else, etc., etc. So those are the injunctive things that can happen, and obviously a reputational impact. You gave your word and you've not performed it. Now, force majeure, as the Black's Law Dictionary, which defines it, it's a brilliant book. I'd recommend everybody goes through it before they graduate law school. So it says it's a contractual provision allocating the risk of loss if performance becomes impossible or impracticable, especially as a result of an event or effect that the parties could not have anticipated or controlled. As I said, you're making a provision for the unforeseen. Now, if you just go to the next slide, there are two terms in our Contract Act, the Indian Contract Act, which kind of um, come close to this force majeure. One is Section 32, which talks about contingency contracts, and one is 56, which talks about frustration. Section 32 is basically when the contingency is actually present in the contract. Say, for example, uh, I would supply you 100 pens if I receive X amount of plastic from company A. So now, this is what the contract says. Now, if company A has not provided me with X amount of plastic, so I'm sorry, I cannot supply you with the pens. Contingency. The other thing that we have is frustration of contracts. Now, when we talk about frustration of contracts, we are looking at conditions which are dehorse the contract, something that has happened which has made the contract impossible to be performed, uh, or the contract was always impossible. Whatever was the basis of the contract, that has been shook. So in that case, it becomes, you can actually go to court and say that there's been a frustration of contract. Now, force majeure has a lower standard than frustration, because force majeure, parties have agreed as to how they'll go about if X event happens, and that is a contractual term. If you do not have that in your contract, then you would say that you would opt for, say, frustration of contract and say that it has become impossible to perform. Now, it is easier to prove force majeure because, again, it's something that the parties negotiated. You've signed a contract. It is implied that you entered into with open eyes, so you know what you've signed or what you've signed up for or what you have surrendered yourself for. But at the same time, if that's not present, then you have to go. The threshold has to be really high, and you have to prove that you set out to do something and it became impossible for XYZ reasons, and you have to prove to a court that you just couldn't have performed it. So that is how it differs. Now, we're following the same principle at the end of the day. We're all talking about how something has become difficult. But if you're going for invocation and if you're invoking a force majeure before the court, then you have to be really careful. You have to go for the pros and cons, and you have to see, sometimes you might have a force majeure clause which is not all encompassing. Like I said, it was one of those classic cut copy cases. So there might be a chance that whatever you're going through, say a pandemic, right? Um, any kind of, say, war, etc., which has not been provisioned for, then you'd have to either try to fit it into the definition that you have, and I'll come down to it, that what kind of definitions you usually have for force majeure in your contract, or you would have to say that the contract is frustrated and you cannot perform it. So those are some of the things that you need to say. And we're telling, as in I'm talking about this because, like, I understand that a lot of you are students, and I just hope that we're still not dealing with the pandemic when you graduate, but you'd still have to draft it, and we're all going to come out of this pandemic wiser and draft better contracts when it comes down to it. Uh, Going down, can we have the next slide, please? Looking at what are the critical applicability conditions. So, how do you decide whether or not, or how do you tell your client that whether or not they can go for invocation of a force majeure clause? So, first things obvious, your contract has a FM clause. Secondly, inclusion in definition of contract. Now, see, there are definitions which are inclusive, there are definitions which are exclusive. When we say inclusive definition, it says force measure includes this. So, you're leaving that certain uh, space for something else to fit in. And I'm sure you've already studied ejusdem generis, the principle which says that, when you say A, B, C, D, E, then, and if you don't mention what E is, then E has to be something in line of A, B, C, D. So, if you're talking about, say, there's a flood, there is an earthquake, there is a war, there is a terrorist attack, or any such thing, so that any such thing would have to be read as something which impacts the business in a way that all these other things are impacting it. So you'd have to look at it whether it's a definition which is inclusive or not. Now, when we've mentioned government actions or orders, and I've specifically mentioned that because this was an unprecedented thing that happened in this pandemic. That the government came out with these circulars, notifications, the Ministry of Home Affairs, etc., where they said that, uh, in all these fields, in all these industries, now this is going to operate as a force measure. You cannot act, you cannot, except for these essential industries, nobody can go out, nobody can act, nobody can work. And that is how, the government order came up with force measure. And even if people did not have it in their contract, it suddenly became applicable to them. RBI came up with their own circulars. NHAI, Ministry of Road Transport, etc., everybody came up with their own circulars and said that, this now is going to, this pandemic, this COVID situation, this lockdown, this restriction of movement in our particular area would be considered to be a force measure. So any industry which is falling under this particular ministry, they are automatically getting covered by it. So this was an unprecedented thing. So, this is also now determining applicability, whether you fall under one of those provisions which have been made by the government or which have been made by the ministry under, to whom you prescribe for the kind of activities you carry on in your business. FM even directly prevents, prohibits, makes contract obligations unattainable. Now you'd have to establish a direct contact. Suppose you are a supplier who has to, or you are a transporter, and there are movement restrictions. Then you are directly being stopped from taking goods from one place to another. However, if it's a service that you were supplying online, you cannot say that I could not make a payment to you because there's a force measure, because the payment was to be made, say, through a bank website, and the bank websites are working. So, in a situation like this, you'd have to establish a direct contact. So there has to be an impossibility to perform because of the force measure. Just because there's a force measure, you cannot just sit at home and say that couldn't do anything, there's a force measure. Then likely scope to mitigate impact of event and performance obligations. When we say that there is a possibility to mitigate, we when you're trying to impose a force measure, or you're trying to go under force measure uh, remedy, you'd have to show that there was no scope to mitigate, because at the end of the day, and the courts are going to look at it, especially if your force measure clause in the contract between the parties that you are advising is not properly drafted, or is not exhaustive, or it's not a comprehensive clause. So what will happen is that you would have to show that we tried our best to plug in whatever we could. And you'd have to realize, say, you are saying that there was a lockdown of 20 days and you couldn't perform your obligations in those 20 days. And suppose there was, the lockdown was lifted for 5 days and then imposed again. So you'd have to show that in those 5 days, you tried your best to do whatever obligations you were supposed to perform. Otherwise, you're just taking undue advantage, and that's something that under law you wouldn't be provided with. Because at the you'd have to look at it in a way that everybody was impacted by the pandemic. So you cannot just it cannot be a one-sided application. So that is something that decides the applicability of force measure. Could I have the next slide, please? Right. So this is what I was talking about. The definition exclusions. This is something as law students, I think, something you'd be met with. Uh, you'd have to see what kind of definitions which exist in your contracts, and what kind of definitions would you want your contracts to have. So is it something that is wide and inclusive? It's something which says that anything possible can be included in it. So you'd have to make it as wide as possible and leave a lot of room for improving or for adding things to it. It also depends on what exactly your client is dealing with. Say your client is dealing with something which is an essential service. Your client is dealing with supplying of oxygen, or steel industry, or electricity, etc. That is something which is an essential thing, which is not really going to get impacted. Even if there is a lockdown, the government is going to make a provision for these things to continue. So if you're in one of those industries, you really wouldn't want your uh, clause to be a wide clause, because say you are an industry where you've been asked to go out and carry out your obligations, whatever the situation, but at the same time that somebody who's supplying to you has a very wide force majeure clause and puts their foot down and says that we cannot perform, then at the end of the day, you are the sufferer. So that is something that would have to be kept in mind when you're drafting a force majeure clause. Again, the second kind of definitions we're looking at is inclusive, which list out specific events. Force measure includes lightning, earthquake, it should be lightning, tempest, cyclone, flood, volcanic eruptions, war strikes, etc., etc. And all other events beyond the reasonable control of and not attributable to the affected party. So, this is something which is, again, it is, though it is listing out the provisions, but at the same time, it is setting a tone as to what all can be included. This is the existing generous principle that I was talking about. And then there are the exhaustive definitions, which are frankly very problematic, where you say that it will mean A, B, C, D, and E, and it is not going to move beyond. So if you're stuck with one of those, and this is what happened to a lot of parties during the pandemic, that they had very specific definitions. Say it said it'll include acts of God. Then do you consider COVID spread as an act of God or not? Is something that the court had to interpret. So again, if you're making it exhaustive, then you have to pay attention to what is your industry. If you are in one of those essential services business, then good for you. If you're not, then this is going to be a problematic area for you in the future. Mm, could we have the next slide, please? All right. Now, some other considerations. There are some industry specific practices where you'd want exclusions and exemptions. And when I say this, like the bank example I gave, that suppose you've already supplied the goods and the other side says that we can't pay because there's a force majeure. So there cannot really be, you've not really been stopped from making a payment. You've just, it's a lockdown which is not affecting the banks or not affecting online payments, etc. So that is something that you really need to provision. So even if you're saying that a pandemic means that we don't have to perform our obligations, you really have to make sure what exact obligations are you talking about. You say that suppose there's a dispute and then there is a force majeure event which happens, and you're reaching out to the other party and saying that let's sit on Zoom and mediate, and the other party says sorry, there's a force majeure. So that is not something that is exactly affecting their ability to come online and discuss the dispute out to you, but your business is suffering. So for a situation like that, it's very important that you think of, you get imaginative and think of all the things that could be met with when you have a force majeure clause, and those are performed. And the performance of things which are easy, which can survive a lockdown, a pandemic, or whatever force majeure event that you're meeting with. That's looked into or that's taken into account. Now there's an illustration. I'd read it out if it helps someone. It says that we've just said that this is not sufficient to trigger a force majeure. So retailer A contracts to buy a minimum guaranteed quantity of vegetables from supplier B. Contract FM includes pandemic, government actions, orders, etc., etc. Now, there was a government order of 24th March 2020, and obviously there have been more after this. This is not up to date. And the government order exempts essential goods and services. Now, B dispatches vegetables, A refuses to accept delivery, citing closed store, which they've done voluntarily because essential services are allowed and vegetables and food items are falling under essentials. Can A claim force majeure? And the answer is no, they cannot, because there's a specific order which says that they can work. Could we have the next slide, please? These are some specific examples that we've noted, some specific cases as to how courts have dealt with COVID-19 so far. I wouldn't get into it. It's something that you can always look up. But what I could tell you is that uh, the courts are very big on preserving the status quo in difficult times. So they've gone ahead and granted relief, extending the contractual time, relaxing the repayment schedule, and as in this case, this particular case, there was asset classification which they relaxed, and they were so basically the courts are also they're taking into account and that there is a pandemic, that the contracts are not ably drafted, and so what is the best way of preserving the business relationship and going ahead with it. So again, there is not, we cannot say that A is the strict approach that the courts have taken during pandemic. Courts have taken a very relaxed and very flexible approach during pandemic, and they've given the best. For example, there's a very famous case which became important during COVID, and this was the Halliburton case by Delhi High Court, and the court said there were some bank guarantee obligations, and the court was, they did not see force majeure as applicable. In encashment and invocation of bank guarantees, they were stayed in the light of nationwide lockdown. So it's just something that you need to look at, that the courts have been really factual. They've gone on case to case basis when dealing with pandemic. and they had to do it. They were forced to do it because uh, everything is contract based, everything is based on the industry that you're working in, everything is based on what was the scope for you to carry out your activities and whether you went ahead and did it. Now, again, specific cases, and I wouldn't get into it, but the takeaway is something that you'd have to look at. That if you are advising a client, then you'd have to see whether the sector is classified as an essential service contract. So it doesn't really matter if you have the fanciest force majeure clause with the choicest of words, because at the end of the day, you're an essential service, so you have to go out and perform your services, and you cannot take that defense in the future. And uh, ministry notifications declaring COVID-19 as a natural calamity for purposes of FM, they are persuasive at best and limited application. So, you really have to see that even if there's a ministry notification which says that, say road transport, or there's a RBI clarification, etc., which says that we will relax, or that the other side, the other party, or all parties are supposed to consider it in a benevolent way, or the parties are uh, advised to relax it, and these are the kind of notifications that the ministry gave off. But at the end of the day, we have to look at it that these are directory in nature. So excessive reliance on these clauses to say that there's a force measure applicable or that there's a force measure not applicable is not really something that you should advise the client, because you have to look at it holistically, that how everything is affecting your client. All right, could we have the next slide, please? All right, now there are some clauses where force measures are only applicable to one party. Can you see the next slide? Right. Now there's a still a gray area, but I might as well just bounce it off you guys so that you can research and come up with something. That what happens when there is a clause which is applicable only to one party and not the other party. So it says that party A, in such a situation, the buyer would not be under any obligation to buy. Then what about the seller? Does the seller have the same obligation, as in the seller has the same liberty or not? And if the seller does not have it, and they are affected by force majeure, can they go to court and say that there's an applicability of section 56, that this has become, there's a frustration of contract? And this becomes important because you really cannot go for both of them. You cannot really say that uh, apply your FM clause also and say that my force majeure clause is applicable as per the contract, and then go for a remedy under section 56 also. So that is why it becomes important to note that what happens when the clauses are unilateral, or where they are covering only one party's obligations. Can I have the next slide, please? All right, so this is, how do you go around invoking the force majeure clause? If you're a party who's interested in invoking, or if you're a lawyer who is supposed to be advising, how do you go about it? So, firstly, every contract has a procedure that if there's a FM clause, and they usually read it this way, that XYZ is going to constitute a force majeure. In case of force majeure, within 15 days or within 30 days of the event happening, you have to go ahead, write to the other party, explain where the obligations stand at this point of time, what you've been able to do, what you've not been able to do, etc., etc. So the invocation needs to be in terms of the clause. If it is not, then the courts are going to read it against you, and they'll say that, okay, there was a force majeure clause, okay, you had an obligation, but you did not invoke it properly, and if you've not invoked it properly, you are really not entitled to get the reliefs under it. Then you have to ensure that the other party received your notice. It's not one of those uh, obligations that you can just send it out into the air, and it would. They can also claim that our offices were shut, nobody received it, you didn't send it to us, you didn't email it to us, you didn't send it properly. Then you have to make sure that it is uh, in term, you're the letter that has been sent out is in terms of the contract that you had agreed upon. Your notice should cover everything. Your notice should have the clause. Your notice should have the remedies that you're seeking. What exactly do you want to be exempted from doing? What are the uh, what are the timelines that you could follow, or if you've done something to mitigate whatever losses are going to happen, what have you done? So everything needs to be there. It needs to be a comprehensive document, so that if it goes to court, which it is bound to go if the other party is not agreeable to it, if it goes to court, then you have a stellar case. You have a very strong case to show. Can we have the next slide, please? Now again, contracts without FM clause. So that unilateral party clause that I was mentioning. So Section 56 talks about frustration of contracts, and the language is very strict, and it says there is a very celebrated case of Satyavrata Ghosh Mukmiram, which says that you have, if it becomes impracticable and useless from the point of view of the object and purpose which the parties had in view at the time of entering into the contract. So that is when you're looking at a frustration of contract. So suppose you had a contract that you are going to buy, or you're going to act as a middle person between, or deliver goods which somebody orders on a Chinese website. And now the Chinese website has become, there's a ban which says that these Chinese apps, these Chinese websites cannot function in the country. So your contract to deliver goods which were ordered on that Chinese app in India, it is something that is, it is impracticable. You cannot go ahead and deliver it, because even if you want to, even if you're out there. So that is somewhere where you go for a frustration of contract, especially if there is no FM clause. So a contract to do something impossible is wide, and something which initially, when you entered into the contract, was possible, but it became impossible during the course of your contract. So for those things, this is where you invoke Section 56, and like I said, that threshold is higher than force majeure, because obviously it is not a part of your contract. Your contract had clauses. Your contract gave you uh, ABC steps to follow, and this does not have any steps. So you'll have a bit of a trouble in trying to prove this in court, that you'll have to show that you did everything and the frustration was valid, and when was that event, when did that event occur, and did you take all the possible steps to ensure that you could actually go ahead and perform it, but you could not. The next slide, please. And now, when you go for invocation of a force majeure clause, there's something that you really need to keep in mind. What if it fails? If you do not have a strong case, and this is something that you, as a lawyer, you'd really have to put your brains to, that if it is one of those claims which is not really strong, and if it fails, then what is the aftermath of it? So you've gone to court and you've said that I could not perform this because of force majeure. Court looks at your clause and says that, sorry, this is not force majeure. This is not a proper clause, or this is not what attracts force majeure, or this is not the event which calls for a force majeure. What happens in that case? You've come back from the court, and now you've also admitted to everybody that you did not perform. So now you cannot go and say that we did perform, or whatever we did, it is actually, it constitutes performance in some way. So, you've just given away certain uh, remedies that you could have had. So when you're going for you just need to balance this out when you're advising a client to go for a force measure, that whether or not how strong it is, and you have to tell them, and if you're a client, then you really need to take this into account, that what are the chances of it failing, and if it does fail, then what is it that you are admitting, what is it that you are giving away? So what are going to be your fallback options, and will you be left with any fallback options? So these are the things that you need to look at, and that's why we're saying that what are the consequences, that if you're successful, Um consequences as stipulated in the contract would follow. And if you're unsuccessful, then liability to specifically perform the contract or pay damages would come upon you, because then you have no remedy. Same thing happens with invocation of frustration. If successful, then you need not perform the obligations. Obviously, the other party is going to ask for restitution. They have their claims, and uh, they have their remedies available in law too. But if you're unsuccessful, then again you'd either have to specifically perform it, or you'd have to pay damages for it. Next slide, please. All right. So what is the kind of view that court has taken? Historically they've always taken a narrow view of frustration, because see, contracts is one such field where courts do not really want to get into too much, because at the end of the day the parties negotiated, you have entered into with open eyes, etc., etc. All the things that they teach you when they teach you contract law. They tell you that whatever you enter into, you have, it's a negotiated term, and you cannot really go back on it. So the same applies to an FM clause, that even if there was a FM clause which was poorly drafted, or which was not all encompassing, which was very narrow in its approach, then the courts historically, always preferred a very, very narrow interpretation of it, applicable, non-applicable. But now, in the present circumstances, it's a very different situation, because not only are you reading into your own clause, you're reading into a ministry order, you're reading into a local order which said that, your DM's order which said that this factory cannot work, or people in this area cannot go out to work. So obviously these are very sector specific, industry specific things that I'm talking about, but they did end up impacting a lot of people. So if you're an essential service supplier, and you have your unit in an area which has been declared to be very sensitive during the pandemic, which is on a total lockdown. Nobody can step out. There are orders to that. There's a 144 applicable. So in a situation like that, you go to court and you say that there has been a frustration. There has to be a force measure invoked. That though I was an essential service, but at the same time there were these things. I cannot have my workers, so I'm ready to operate. How do I operate? So all these things have actually been considered by courts at this point of time, because they're essential. So that is something that, this is what the data says. It says here unprecedented Supreme Court order where period for limitation for filing proceedings have been extended. Of course, this is dated. After that, there have been multiple orders, and Supreme Court has also taken. See, so I'm sure you're all aware of the concept of limitation, that if you've been aggrieved, there's a particular time limit which is prescribed within law, in which you have to go ahead and invoke a dispute, or you have to go ahead and go to the court, approach the court, file a case, etc. So obviously that got disrupted during the pandemic. The courts were not functioning in their full capacity. The courts were shut for X period of time. Even now, courts are operating on a hybrid model. The registry may or may not be operating, etc., etc. So all that is something that is being taken care of, and the courts took a suo moto action, and they gave out these orders which said that any limitation which expired, no party should be suffering because of this. So I think it is a very welcome move. It's a very bold move that the courts have taken, and they've taken a very, very logical, reasonable approach to this. Now, what is the material consideration in dispute resolution? Uh, we're talking about this again because sooner or later, if one party is agreeable to a force majeure event happening and one party is not agreeable, one party is affected unfairly, etc., it is going to go to court. So there are certain things that you need to look at. Now, obviously, first one we can eliminate. We are in a common law country. Force measure notice. So when did the event occur? Was it sent at the correct time? Then interpretation of FM clause. If you are the party who has invoked the force measure, then the burden of proof is going to be on you to prove that the force majeure event actually occurred. then what is the relief that you're looking at? What are you asking for? You are saying that you cannot perform it. You are saying that there should be a suspension for a period of time. You're asking for a time extension. You're asking for a price negotiation. Especially if this is not mentioned in your contract, then it becomes very important that you really need to think it through, that what are you going to court for? Because you might just say that I want a time extension of 6 months, and after 6 months you realize that the situation is still not changed, and you still cannot go ahead and produce or deliver, or you cannot manufacture, etc., etc. And then you really need to see that what does your contract provide for? Does it provide for a mediation, conciliation, arbitration, litigation? So what is the remedy that is available to you? So that is also something that needs to be kept in mind. So suppose uh, it's a force majeure clause that you really need to invoke right now, but there's a longish procedure. It says that there's going to be a 1 month mediation period, then there's going to be 3 month conciliation period, then there's going to be an arbitration, etc., etc. So that is something that you need to look at, and uh, if you're a client, then you need to look at the timelines which are going to be affected, because maybe your contract period might get over in the set time. And if you are um, a lawyer advising the client, you also have to look at it and give them some realistic timelines, that what is the time period in which we see a dispute, which is a force majeure dispute, to resolve. I think that would be all from my end. I could take any questions.
Am I audible, ma'am?
Yeah, you.
Apologies for the network issues, ma'am.
That's okay.
Thank you so much, ma'am. You really enlightened us regarding this topic, and it was quite informative. So, if it pleases you, ma'am, now can we move towards the question answer session by taking up the questions?
Sure.
Ma'am, the first question is how the
Hmm.
contracting parties can establish that the outbreak of pandemic and its effect had unforeseeable consequences on the performance of their contractual obligations.
How the parties can proceed? It depends on what are the clauses of your force majeure, as in what is the force majeure clause in your contract. Also, you have to see that what is your industry. You'd have to prove somewhere that you were affected in a particular way, and there was an impossibility to perform, and that's why the force majeure is getting attracted. And what was the last limb of your question, Piyush, again? Could you repeat the last bit of
Ma'am,
your question?
yes, ma'am. Its effect has unforeseeable consequences on the performance of their contractual obligations.
So see, what unforeseeable, like I said, that it all depends on how it has been drafted. Your force majeure clause has been drafted. So if it is an um, very exhaustive definition which says that ABC happened, then you'd have to prove that ABC has happened. And as to how it has impacted you, that is something that will depend on empirical data, facts and circumstances which you prove in the court, that you show that this is what we were supposed to produce, we couldn't produce, or this is what we were supposed to manufacture, we couldn't manufacture, this is the service we were supposed to provide, we couldn't provide. And that's all, how you prove it. That's just like how evidence is proved in any case. That's how.
Thank you, ma'am. Ma'am, the next question is if we have had a exhaustive list in the contract and later government policy changes with impossibility of performance in new context, what value exhaustive list will have?
What value that exhaustive is? See, as a person who's affected, you would have to look at what is the mm, most beneficial thing to you. So if you are somebody who's been impacted, like I said, that you have your clause did not have it. Your clause did not say that a pandemic is a force majeure event, and there's a ministry circular which makes you fall into that category, which would be impacted by a force majeure event. Then obviously you're going to go for the ministry circular, and you're going to forget all about your contract, because you need to catch on to what is more applicable to you, more beneficial to you. What value will your clause have in that case? Okay, so in this particular case, you as a person who is affected and who does not want to follow your contract but wants to follow the ministry circular. You're going to say that that is overarching, obviously. If you're somebody who is on the other side of it, then you are going to try and establish that we have to stick to our contract, this does not apply to us. And then at the end of the day, it's something that will be subject to interpretation, how the courts interpret it, how they see whether or not what you're talking about is actually true. And again, you'd have to look at the ministry circular also. If the ministry circular says that it is advised that you do not do this, or it is advised, or it is advised that parties may consider this, then it's a very it's a requesting soft language, and we cannot really use that in the court to say that now this force majeure clause has no power at all and we really need to only depend on the ministry circular. But if it is something which is a directive of sorts, then obviously in this case, in this particular case, your clause at this point of time has really less value, right?
Thank you so much, ma'am. Ma'am, that's all the questions we have.
Great.
Now, moving further with the vote of thanks. Thank you so much to our esteemed speaker for sharing her knowledge, enlightening each of us through her words of wisdom. It's a great pleasure to listen from you on this topic. We are deeply thankful to you for taking your time out and imparting to this session, and also our team will look forward to have more sessions like that with you.
Thank you. Thank you so much.
Thank you, ma'am. Thank you, ma'am.
Have a good Sunday,
Moreover,
guys.
I would I would like to thank team members of YURIS JURA, without whom this webinar would not have been a successful one. I hope today's
Thank
session
you.
is fruitful for all the participants who joined us through across the country. We shall be looking forward for organizing more such events for creating awareness about the legal field for the law aspirants and to bring you the best legal fraternity for enhancing your knowledge. Thank you so much. Once again, thank you, ma'am.
Thank you. Thank you, guys. Have a good Sunday.